Hello, everyone. Welcome to another live broadcast from the Ottawa Business Journal. I'm Michael Curran, the publisher of OBJ. Thank you so much for joining us. As usual, we've got a great topic, but it's one that we've never covered before. And I think it's highly relevant to all you entrepreneurs and business owners who are watching and are listening. At the same time, I think today's topic is very taboo. It's outside of the regular boundaries of regular business conversations. Let me set this topic up for you a little bit. Establishing and operating a business often seems like an impossible task. There's challenges everywhere. Acquiring customers, funding the business, hiring and engaging great employees, keeping up with innovation, adjusting to economic changes. All of those are very real threats to your business. But the threat we're talking about today is one that doesn't get talked about in the boardroom. It's more likely to be talked about in the bedroom. I know that sounds odd. Today, we're talking about business, marriage, and separation, how to protect your business in the case of divorce. When faced with life changes such as divorce, all of that hard work in your business can be wiped out, and possibly the business venture could fail. For this reason, there are things that business owners must consider in advance. Here are some of the things we're going to learn today: how to structure your business to minimize vulnerability in divorce proceedings, how to understand the implications of different ownership models on your business, legal tools such as prenuptial and postnuptial agreements to safeguard your business interests, and finally, how to develop a comprehensive plan to ensure business continuity and minimize financial disruption. As always, we've enlisted the help of an expert to guide us through our discussion today. Today's expert is part of the team from Nelligan Law. Nelligan is a locally headquartered firm that dates all the way back to 1969, and its lawyers really distinguished themselves in areas such as employment, estate, business, and family law. Family law is the important one today. Our guest has more than a decade of experience in managing complex financial issues that affect separating couples who own their business or shares in the business. These cases, our guest works closely with a team of experts such as business valuators, corporate lawyers, forensic accountants, and tax experts to get the best possible outcome for her clients. Without further ado, let's welcome our guest now. Here is Jenna Preston. Hey, Jenna.
Good afternoon, Michael. How are you?
I'm very well, and I thank you for sharing your expertise in advance. And as I mentioned in the lead up to our chat here, Jenna, I kind of feel like this is a topic that is taboo. Like, this is not a topic when I'm talking to other business owners and entrepreneurs that gets discussed. Would you agree with that premise?
I would. I think separation and divorce generally is a fairly taboo subject, despite its prevalence in our communities and our families, whether it's something that you're personally experiencing or whether it's something that a family member or a friend is going through. But we don't often talk about it, and we don't often think ahead of what we can do maybe to uncomplicate the situation if it does happen.
Yeah, I'm so glad we're talking about this because, again, I think it doesn't get enough attention. And this is, like so many legal topics, one that people need to consider in advance. So listen, we've got a great agenda today. I'm going to walk everyone through it. We've broken things down into 4 digestible topics, and we'll run through them here now. Topic number 1. We'll talk about the semantics, and it's not just semantics, as our graphic will show in a second, between separation and divorce. There's real differences between those. In topic number 2, we'll talk about how to structure your business smartly. In topic number 3, joint versus sole ownership. In topic number 4, contracts. Can you guess what we're going to talk about? Contracts. And then sometime around 12:25 for our live audience, we'll be looking for your questions. So this is a unique opportunity to ask Jenna, an expert in family law, all of your business ownership questions related to divorce or marital breakdown. A reminder, whether you're on LinkedIn or YouTube, you can ask your questions in advance. One of our OBJers will be helping out solicit some of those. So ask those questions in advance, and we'll stack them up and moderate them for you. All right, Jenna, ready to dive right in?
Let's go.
Okay, topic number 1, understanding the difference between separation and divorce. Take it away, Jenna.
So I think the terms often get a little bit conflated when people are discussing relationship breakdown. And I'm careful in saying relationship because there's a difference between separation, which can happen for married spouses as well as common law spouses, whereas divorce really applies to the breakdown of a married or a marriage. So when you're looking at divorce, you're looking at a court order that's legally terminating the marriage between two individuals. It can have different implications. For example, it can impact the right of a spouse to possess or reside in the matrimonial home. It can disentitle a spouse to ongoing coverage under the other spouse's medical and extended health benefits. Whereas separation is the actual intention of at least one of the spouses to end the relationship. It doesn't have to be a mutual intention, but there does have to be some sort of corresponding behavior indicating that the relationship is over. So separation applies whether you're married or not, if one spouse develops an intention to separate, whereas divorce is specifically for those who are married and the marriage is over.
When I'm thinking about this, Jenna, and I'm a neophyte in my thinking, so forgive the dumb questions. I think that you likely would engage with business owners or entrepreneurs at the separation stage. In the divorce stage is when potentially the ownership of businesses and that gets real. But help sort that out for me, like from a chronological, if I could put it that way, perspective. When are you typically bumping into people in this difficult situation?
That's a great question. And I think so. Once separation happens, it gives rise to issues that need to be addressed both in the parenting context and in the financial context. And so after separation, that's when I would meet with a client and discuss how they're going to deal with the financial aspects as well as parenting when those are present. The financial aspects of the separation, and that can include how they're going to divide a jointly owned business and or how the value of a business is going to be addressed in the context of separation.
Okay.
Only once all of that has been dealt with can you then apply for the divorce order.
Yeah. And I'm understanding something in your answer was a great one, that you're taking a little bit of a holistic approach, right? So we're going to focus today, of course, on business ownership and how that gets divided. But you're also talking to your client about children, maybe a matrimonial home, finances, and then it's leading to probably a bit bigger discussion around ownership of the business.
Right. Ownership of the business would fall into the property issues that need to be addressed. Ongoing income from that business would flow into conversations on support, but it is something that all gets addressed together, including the parenting issues.
And I'm just sensing the discussions you must have. They would be highly complex because, as you said, there's common law, there's marriage, there's families, children's financial issues. Wow, that's custody issues. It's recognizing why we need someone like you to walk us through this. Excuse me. So, in topic number 2, maybe we'll move to that one.
Mhm.
Reminder, by the way, if you're watching live, we want to see your questions early. So again, if you're on YouTube or LinkedIn, please type in those questions nice and early, and it maximizes the chance, quite frankly, it will get to your question. All right, topic number 2. This one sounds like a really important one, and one of those things you need to think about potentially in advance, Jenna. It's structuring your business smartly. Tell us more about this topic.
So before I go there, one thing I just wanted to clarify is that when you're looking at dividing a business, there's a distinction between dividing the value, which would happen whether or not the other spouse is a joint owner, versus dividing the actual assets, so dividing the company itself or the ownership of the company. So there is a little bit of a a distinction there that will come up later. And I think it plays into how you are going to structure your business.
Exactly. Yeah. Yeah. I skipped over a point there. You're right. Very important to think about the division of value versus division of jointly owned assets. Number 2. So let's dig into that one. Structuring your business smartly. Maybe talk to us a little bit about the tax benefits.
So I'm not a tax expert, so I won't give tax advice, but I often hear that clients will come in and they'll have a jointly owned business with their spouse, And they'll tell me, well, I was advised to make my spouse a shareholder to be able to take advantage of some tax benefits. For example, there's a lifetime capital gains exemption that's available for certain types of shares in Canadian controlled private businesses. So there are definitely some tax advantages that can happen when you bring in the other spouse as a shareholder. But again, that joint ownership piece becomes very problematic if the relationship breaks down, and gives rise to a whole host of issues that need to be addressed, not only dividing, again, the value of the business, but dividing the business itself. And can you come to an agreement on what's going to happen with that business and hopefully ensure its ongoing operations?
Mm.
So some different ways to think about that. Again, it's all about, I think, forethought or foresight, is to perhaps structure your business in a way that will facilitate any sort of division or any resolution if the relationship does break down. One of those ways would be different classes of shares. So when a corporation is established, there are often multiple types of shares that are available and can be granted. Common shares will often carry voting rights, for example. They typically have the right to receive dividends and income from the business. And then you have preference shares, which have more limited rights, but often a fixed value. So working with your corporate lawyer when you're setting up the business, and being aware of the different implications that can have if the relationship does break down, could help you on the other end of the relationship if something bad happens. The last thing there before we move on was just, and again, I'm not an employment lawyer, but it does come up as well. If a spouse is contributing to a business's operations, it's very important to be mindful that an employer-employee relationship can also arise, and that gives rise to its own class of issues that can arise if the non-operating spouse and the business is still contributing. They can be seen as an employee and they may have certain rights, whether there's an employment contract in place or not. So again, it's just making informed business decisions when you're deciding how to operate your business and the role that the spouse is going to play, whether they're an owner or not an owner.
I think you're spot on with so many of these comments, Jenna. And often, as you indicated, just to pick up on that first one, um, as it relates to capital gains, spouses will be brought on because there's, the tax experts are always looking forward to the potential sale of the business and trying to minimize tax. And really interesting to hear that there could be different classes of shares that helps kind of mitigate some of those issues. And then I would have never considered that last one, but you're right. If a spouse is working in the business, is there actually an employment agreement with that person? Because they could be potentially an owner, but also employee. Whoa. When is the ideal time to talk about some of these issues? I presume it's as the corporation's being set up, Jenna.
It is. And unfortunately, I don't have that many of these conversations, but it would help, because if you're making these decisions in structuring your business, even though it can be an uncomfortable conversation to have, it could help if things do go off the rails with the relationship and you're now trying to figure out how you're going to move forward. It's better to get ahead of it rather than try and deal with it on the back end.
I think you're providing really unique advice, and I've watched other entrepreneurs launch businesses and that, and I don't think any of these discussions have happened, right? Yeah, for sure. There's like a capital gains discussion, there's a shared discussion, but I don't think it's ever within this context, Jenna. So to me, you're really highlighting why this stuff needs to be thought about in advance, and some sort of agreement needs to be reached. We're off to a great start here, Jenna. We're coming up for our audience in about 10 minutes or so to those live questions. So again, if you're on LinkedIn or YouTube, start sending us your questions. We'll get to them in just a few minutes. In topic number 3, Jenna, we're going to talk about joint versus sole ownership. Tell us more.
So if you're separating and you're a married spouse, you're not only worried about dividing the value, but you're also then worried about having to divide the physical assets. So joint ownership, assuming there's joint ownership, sorry. So for joint ownership, you're looking at a division of value. That would be if you're married and separated through a process called property equalization, which I won't get into the details of that, but it does look at just trying to divide the value and ensuring that that is equally shared between the two spouses. But once you divide the value where you have joint ownership, as I mentioned before, you also have to untangle that and figure out how the business is going to move forward. It's very rare that two separating spouses are going to want to continue operating a business together and or be able to, given a lot of the conflict that often results in relationship breakdown will carry into the employment or the business context as well. So it's trying to figure out how you untangle that, and that can be guided by way of a shareholders agreement between the spouses that sets out what happens when what would happen rather when the relationship or if the relationship breaks down. And there's always, you need to be aware of, and again, in trying to plan, you need to be aware that there are limitations on what you can do in trying to structure things in advance. And on the slide there, I've just mentioned equitable or fairness-based claims, a very not common because it's a high threshold, but one that is used is what's called the oppression remedy that can be used by one shareholding spouse against the corporation if they're being treated in an oppressive or unfair manner. So that is something that you do need to be aware of, even if you are planning in advance, because the oppression remedy is something you cannot contract out of and can be used between two shareholding spouses. If you're looking at sole ownership, again, you're still needing to consider the division of value. However, there's different equitable claims or fairness-based claims that could be used to address the ownership piece. So at law, one of those would be what's called a constructive trust. And that's where one person, I'll simplify it, it's much more nuanced, but where one person has contributed to a piece of property or some property like a business, they haven't been compensated, duly compensated for that contribution, they've been deprived. And there's no reason why that deprivation should stand. So instead of paying out that spouse, it is possible for them to claim an ownership interest or be deemed to be a joint owner depending on those contributions. So as you're structuring your business and you're operating your business, it's very important to just consider, again, the role that your spouse is playing. Are they a shareholder? Are they contributing to the ongoing operations? And just being aware of the ramifications of that as you move forward.
One thing that just occurred to me, Jenna, and maybe I'm way off base on this, is the how a valuation formula potentially could help at when the shareholder agreement is being struck or any sort of agreement between partners. Just a formula, again, maybe it's revenue based, maybe it's a multiplier, that type of stuff, to say, the value of this company when it comes to shareholders disputes will be the value of the business will be determined in this type of way. Is that realistic, or do you need to bring in a business valuator expert to sort through things?
So typically we would bring in a business valuator if the value of the business. So if there's a dispute between the spouses on the value of the business, if they don't agree, then we often rely on certified business valuators to determine that value. And it depends on the nature of the business, whether it's a going concern. They often look at income and multiples of income to figure out what that value would be, whether the company is, on the market or not. Has it done funding rounds recently? Is it publicly traded? So that's something where, as a lawyer, I'm trained to identify issues, opine and advise on issues within my wheelhouse, but that type of business valuation would be done by an expert. And then we would use that value in trying to negotiate or resolve the division of the business.
And I'm curious, when it comes to a business valuator, would that person be appointed jointly, so to speak? So both parties are agreeing that the determinations of this person will be kind of final, or will set the valuation, or does one party appoint the valuator and then that just leads to another series of conflicts?
The courts would prefer that we have joint valuators, just because it can try and minimize the areas of dispute. But more often than not, one party will retain a business valuator. They will get the value of the business. And if the other spouse disputes that value, then they will retain their own business valuator. They will either have a critique prepared or their own report. And then the experts can, try, it's a terrible term, but they ask the experts to hot tub and come to some sort of agreement on the value. And if not, then it can go all the way to a trial, and it's left to the trial judge to determine what value to apply to the business.
I've never heard the term hot tub. That's fascinating.
It's a terrible term. It's a really terrible term. Yeah.
Okay, really interesting. I'm learning so much here. Okay, we're going to move to topic 4. We already have some questions, but again, we're about 5 minutes away from the interactive component of today's live broadcast. So if you're watching us live, LinkedIn, YouTube, use the comment section. All right, topic number 4, contracts. We're going to talk contracts. Tell us more, Jenna.
So there's different types of contracts that could help, plan in advance, I guess, for lack of a better way to put it. And 2 of those are cohabitation agreements and marriage contracts. People will often refer to marriage contracts as a prenup, but in Canada, in any event, we refer to them as marriage contracts. Same thing. Cohabitation agreements apply between 2 individuals where there isn't a marriage on the horizon, and it can address property and support claims. Marriage contracts will address the same types of claims, property and support claims, and but between 2 spouses who are getting married or who are already married. And you tend to address the circumstances or what will apply in the event of a relationship breakdown. So you can imagine they're difficult conversations to have, but again, if you can have them in advance, it can really streamline the process if the relationship does break down. 2 things to flag, however, well, at least what's showing on my slide, is that with these contracts, there are still limitations in terms of what you can provide for when it comes to employment rights. So as I mentioned before, if you have one spouse who's contributing to the business, even though they may not be a shareholder, there could be an employer-employee relationship that arises, regardless of whether there's an employment contract involved. And under the Employment Standards Act, there's a minimum amount of severance that is owed. You can't contract out of that. Same with business law. When we talked about the oppression remedy, as I mentioned, you can't contract out of that. So you cannot put something in one of these agreements that allows for one shareholder to behave in an oppressive or unfair manner towards the other shareholders. So those are, in the family law context, those are 2 types of contracts that could be put in place in advance to try and set some parameters or some structure about what will happen with the business and the shares. And on the back end of a relationship, the separation agreement, this is where you would have resolved the issues arising from a relationship breakdown, but it would include several releases as well. So to try and ensure that the other spouse can't come after the business down the road, there would be several releases involved in that as well. And then finally, in the corporate context, when you're making a spouse or any other shareholder a shareholder, it should be accompanied by a shareholder agreement. And I often see individuals who have small businesses that are incorporated where the minute book isn't necessarily kept up to date. They don't have the corresponding shareholder agreement in place. It is very crucial that these documents be prepared and put in place and kept on the record. And shareholders agreements, again, can address what will happen between shareholders if something happens. They can apply between 2 spouses who are shareholders, and they can also apply between kind of third parties. So you can have unrelated shareholders who can try and address or will try and address what will happen with one of their shares if their marriage breaks down, and what the other shareholders have the right to do or not to do. So there are various ways to try and plan in advance, to try and structure things, to try and protect your business. You just want to be able to do that in an informed way. so that you're making the best decision when you're taking into account all the different risks in the different areas.
Wow. So so many takeaways there. I can't imagine, the difficulties if there wasn't a shareholders agreement at the start. I got another dumb question though. When it comes to cohabitation or a marriage contract, are you typically seeing those when there is, I'll call it, an imbalance in wealth coming into the relationship? Is that typically when you'd bump into someone, or is it, or should it be considered under any circumstances?
I mean, we most often do because the individual with more wealth is trying to protect their wealth in the event of a breakdown. They may also just be more informed or have individuals around them who are more informed that there is a risk to their wealth and they should be planning in advance. But surprisingly, I do get relatively young individuals who come in and are asking for these contracts simply because, whether they're business owners or not, just because they want to plan in advance and they don't want that uncertainty if something does happen.
Interesting. Would you
Mhm.
say this is a bit of a, I'm asking all these off key questions. Would you say the younger generation might be more open to this? Like, is this a discussion where, or a situation where people from a younger generation are just more prepared to have these discussions, Jenna, or I'm a little off base there in what I picked up?
I think it's all over the map.
Okay.
I think we do get individuals who are on second or third marriages, for
Oh,
example, who have
okay.
been through it before and they want
Got
to
it.
avoid it. And we also get younger individuals who just want to take more control and they may have a bit more knowledge, whether
Hmm.
because they've watched their parents divorce or
Sure.
relatives. So there just may be more of an awareness
Yeah.
around it now, given the prevalence of separation and divorce in our
Yeah.
society compared to before.
I completely get that. Depends on what they've experienced, likely, or what their friends and family have experienced. So, listen, we're into our Q&A session, and I kind of predicted we might get some questions on family trust. So, this is like a whole other
Hmm.
level of complexity, but it's something that's a mechanism that's being used more and more, right, Jenna?
Hmm.
So, I'll throw this one on the screen here. For all of our viewers, please, understand that Jenna's seeing these questions for the first time, and this law is such a complex thing that at best, Jenna, you can give us kind of the surface level answer. But Sean McKenzie, if I get that name right, is saying, if possible, can you comment on the implications of an existing family trust, which has both spouses as trustees and beneficiaries, and how divorce impacts on the trust? Any comments or thoughts on that, Jenna?
So, if you're looking at the impact of divorce on the trust, uh, in the divorce context, you'd be looking at dividing the value of property of both spouses, and that can include a trust interest. So, the value of each spouse's trust interest would need to be determined, and then that would be equalized if we're talking about married spouses who have separated. How the trust is actually going to operate or dissolve or what's going to happen between the trustees would be dictated by the trust deed. So that would be something determined under the trust deed. And I don't practice in trusts. I don't settle or
Yeah.
establish trusts. However, if you're thinking of setting up a trust or if you have a trust and you're concerned, I would go back to the trust deed, see what it provides, and if you have questions, consult with the lawyer that set up your trust to make sure that there's enough clarity there to see what, or determine what will happen.
Okay. Good, good to know. By the way, shout out to Jerry Dowler, I think it is, who was also asking the trust question. I wanted to ask something that's kind of implied in some of the comments here about your role specifically. So,
Mhm.
and forgive me for using this analogy. Is your role in this kind of the quarterback? So there's several experts on the team, there's several players on the team, but you as the central lawyer in these family law matters, Jenna, trying to quarterback this. Is that how it typically plays out?
Based on my limited knowledge of what a quarterback does,
Okay,
I would say I
the
would say
central player.
yes. Yeah, I get it. No, I get it.
Yeah.
No, I would say yes. I mean, so one of the things I love about family law is I get to interact with a whole bunch of different areas of law, different issues. And so often, as I mentioned before, my job is to identify those issues, recognize what's within my wheelhouse and what's outside, and then bring in the experts when and where needed. So I often work with, corporate lawyers. I'll reach out to colleagues of mine in employment. I'll talk to tax experts and accountants. I'll talk to certified business valuators, because when we're dealing with a marriage or a relationship breakdown, we need all of the inputs to be able to then determine how to deal with not only the division of value, but how to divide the physical assets. And when we're dividing the physical assets, again, there's so many tax implications that it often ends up where we're working with tax experts or estate planners to figure out the best way for this family to unravel, whether it's a business or a trust, in the most tax efficient way and in a way that will impact the operations of the business the least amount possible.
Okay. And I would imagine, given your experience in this and Nelligan's tenure in the market, history in the market, you probably have a lot of established relationships. So I think one of the things, one of the benefits of dealing with someone like you, Jenna, would likely be who the players are. You have access to them, and you can bring them in as needed. Is that fair to assume?
Yes, I mean, it is great, and Ottawa is a smaller community. I used to practice in Toronto,
Okay.
and it's much larger. But in Ottawa, certainly, there's some great business evaluators, very wonderful accountants, and here at Nelligan, we do have a multidisciplinary firm. So I'm lucky I can go down the hall and ask those questions to my colleagues who are the experts in those areas.
For sure. And maybe as a final question, I'm going to ask something that isn't really fair, and you can't is difficult to answer. I'm going to ask you a time-based question.
Sure.
So, again, I'm sure there are some of these matters resolve themselves super quick, and some of them probably go on for a decade. But if there's someone watching, let's presume, Jenna, they haven't done the advanced work, but that's probably often the case. So they're coming to you, and a separation or a divorce is imminent. Should someone what should their expectations, maybe in terms of a time range? Is this going to take a year to resolve? Is this going to take 5 years, 10 years? Any input on that point?
It's all over the map,
Okay.
because it really, to resolve these issues, whether you're the shareholding spouse or whether you're the spouse who doesn't hold the shares, but you're entitled to some of the value in the business, a lot can depend on the level of cooperation from the other spouse. So, can you get the financial information? Do you have it available? Do you need the business valued? How long does that valuation take? How complex is the business structure? And then also, are there parenting issues, which can also take a very long time to resolve? And typically, these things will resolve as a whole rather than piecemeal, although sometimes it is done piecemeal. So unfortunately, I can't give you an estimate, but they can last a decade. They can be done in the span of, a year or 2 years, which would be a pretty good timeline.
Yeah.
But if you have a very simple business structure, it doesn't need to be, if it's a flow through for income, for example, as a doctor or something like that, it doesn't need to be that complicated. It really depends on the nature of the business.
I think that's a that's a very sensible answer. It's going to depend on the two parties' willingness to come to agreement.
Yeah.
I'm sure that's a giant factor, and then the other thing would just be the complexity of the business, the assets, the size of the value and that type of stuff. All right, Jenna, let's go into our takeaway phase. So we're going to bring up another graphic on screen, and you can just summarize some of the key takeaways here as we wrap up.
So, to summarize everything, I think you want to consider the different implications. So, there could very well be very lucrative or beneficial tax advantages, among others, to structuring a business in a certain way. My advice is just to be aware and make informed decisions about how you're structuring things, how you're operating your business. So, be informed. And to the extent you can, plan ahead. I appreciate that I'm likely advising what may seem to many the impossible, which is to have those conversations during what may otherwise be a happy relationship, on what will happen if the relationship breaks down, and Because spouses often see their contributions to a relationship and a business very differently, again, can be difficult conversations, but to the extent that you can have them and manage expectations, I think it really helps on the other end of the relationship.
That's great. Great wrap up. And I would presume, Jenna, that to give, again, given your experience, you could help, maybe I'll put it this way, create a safe space for those discussions to happen. So is the scenario where, two spouses, partners would come sit before you and you could walk them through some of these issues?
Unfortunately not. So I
Okay.
can't meet with both spouses. It would
Advise one
be
of them only.
contrary to my rules of professional conduct, but
Okay.
I'd advise one, and I would encourage the other one to go seek independent legal advice so
Excellent.
that they're being informed about their own rights and obligations.
That makes complete sense. All right, we've only, as always, scratched the surface on these issues. If you are need advice, here's how you can contact Jenna. There you go, right there. So once again, it's Jenna Preston, the partner and family law practice group at Nelligan Law. You've got a phone number, you've got an email. For everyone who is registered, that's the key point, registered for these advanced broadcasts. One of the benefits is we'll send you the slide deck and we'll send you the contact information for our expert. Jen, I want to thank you for all your time today and sharing all this expertise. Thank you very much. We truly appreciate it.
Thank you very much for having me, Michael. It was great.
Okay, we'll see you soon. Cheers.
Bye-bye.
All right. Well, just as we wrap up here, a couple OBJ-related items. Reminder that you can visit obj.ca website every day for the latest in local business news. I highly recommend you subscribe to our weekday email newsletter, OBJ Today. I know you're thinking, what are you talking about? Another email in my inbox. This is an email that really summarizes the day's event. You get a really quick synopsis of what's happened in Ottawa. And it probably saves you a little bit of time and keeps you informed is the key point there. Again, follow us on social media. OBJ just eclipsed 40,000 followers, so we got a big following there. And for those of you who are on YouTube, please click the red subscribe button. And there's also a little bell icon. And if you hit the little bell icon, you get notified when our new videos get posted. That's all the time I have for today. So on behalf of our friends at Nelligan Law and OBJ, thank you so much for participating. Hope to see you soon. Bye-bye, everyone.